If you are a Georgia personal injury lawyer and you handle claims involving governmental entities, particularly sheriffs, you need to read the case of Collington versus Clayton County. Now, in that case, the court was addressing OCGA section 36-11-1, which has the requirements for sending notices to counties whenever somebody is injured and has a claim against a county. Now, there have been cases that have distinguished between claims against a sheriff in his official capacity and claims against a county. And there had been some confusion about where you send the notice that must be sent within 12 months when the claim involves a sheriff. Now, in Collington, the Georgia Supreme Court held two things. The first question in Collington was whether a claim against a sheriff was even a claim against a county that triggered a notice requirement. And the second question was, if the statute does apply and a notice must be sent, where do you send it to? Does sending the notice to the sheriff, does that meet the requirement? Is that the only way to meet the requirement? Or do you have to send it to the county as well? And so answering the first question, the Georgia Supreme Court held that somebody who has a claim involving the sheriff must send a notice pursuant to 36-11-1. Now, the next question, where can that notice be sent? The Georgia Supreme Court finally provided some clarity and held you can send it to the county. The court's reasoning was really interesting because despite there being a line of cases going back decades distinguishing between claims against sheriffs and claims against counties, the Georgia Supreme Court acknowledged that a claim against a sheriff in his official capacity is essentially a claim against a county. After all, that's the whole reason that the statute applies and requires you to send a notice when you have a claim against a sheriff. So sending a notice to the county is sufficient when you have a claim against the sheriff in his official capacity. What the court did not address and left open for another day is whether the statute has been met if you send the notice just to the sheriff. Now, I think it would be sufficient to do that, but here's what I would advise all Georgia lawyers who are handling these cases. Do the belt and suspenders approach. Whenever you have a claim involving a sheriff, send it to both the sheriff and to the county board of commissioners, to the chairperson of the county board of commissioners and every member of that county commission, the county manager, the county attorney. Send it to as many people as you can because it's not going to hurt to do that and it can help avoid needless litigation on that issue. One of the other things that is going to be interesting to see after the Collington case is, do you continue to name the sheriff in his official capacity as the defendant, or do you name the county? Because if you read the reasoning from the decision, it really doesn't seem to make a difference because in essence, you are suing the county when you sue the sheriff in his official capacity. Now in this regard, again, I'd recommend the belt and suspenders approach. If you have a claim involving the sheriff, sue both the sheriff and the county. In the litigation, you can get some sort of stipulation from the defense attorney as to who the proper party is, and you can avoid any delay in your case from having to address a side issue. So if you do handle claims against sheriffs, it is sufficient to send the claim notice under 36-11-1 to the county. But I would recommend you still send it to the sheriff and the county as well, and that when you file the lawsuit, that you sue both the sheriff and the county.